Hi, I'm David Cornwell, a director with intellectual property law firm Sterne, Kessler, Goldstein Fox. Today I'd like to share a few thoughts with you on inter-partes review and in particular on the appeal process. As most of you know, the inter-partes review is a patent office procedure in which a member of the public can challenge the validity of a patent. There are three issues that I'd like to address today. The first is that a decision not to institute an IPR is not appealable. Petitioners are often dismayed to find that although the petitioner lays out multiple very good reasons for invalidity, the PTO exercises its discretion and institutes an IPR only on a single ground. The instituted ground may or may not be the strongest ground of invalidity. Therefore, the petition must go through trial on an issue that is not the strongest issue. Although some suggest that the Patent Trial and Appeal Board does not have the power to summarily dismiss appropriately raised grounds of rejection, this issue has not yet been resolved. Therefore, it may be important to use your 60 pages wisely by limiting your argument to the single best proposed rejection. By doing so, you're at least going to be appealing your best case if you lose at the board. The second issue that I'd like to address is that of standing. In Consumer Watchdog versus Wisconsin Alumni Research Foundation, Consumer Watchdog filed an inter-partes re-examination. Consumer Watchdog had not been accused of infringement, but as a member of the public had a right to try to invalidate the patent that was owned by Wisconsin Alumni Research Foundation. Ultimately, Consumer Watchdog lost and elected to appeal. On June 4th, 2014, the Federal Circuit held that it did not have jurisdiction over the appeal of the inter-partes re-exam decision, even though the statute provided the right to appeal. The Federal Circuit would not take jurisdiction over a case in which the party seeking court action had not suffered a concrete personal harm. There is no reason to believe that the Federal Circuit will also have jurisdiction over an IPR appeal under the same circumstances. Therefore, if you are filing an inter-partes review as a member of the public, but have not been accused of infringement, you may not be able to appeal an adverse decision. The third issue that I'd like to discuss relates to general principles of an appeal. A party cannot appeal issues that are not properly before the board. For the petitioner, this sometimes means that the requester needed to have raised the issue in the original petition. As a simple example, a petitioner might challenge a patent as being anticipated by the prior art. If trial is initiated on the issue of anticipation, the board will not determine issues such as obviousness. So an important lesson is to make sure you have an issue to appeal. The board does not examine patents in the same way as a patent examiner might examine a patent. It does not raise rejection sua sponte during the course of a trial. The parties to an IPR cannot shift gears in the middle of a trial. Therefore, it is critical that the parties place into the record the issues it will need to raise on appeal. These issues must be raised in a timely manner. Lawyers can be frustrated by the board's inflexibility regarding certain issues. For example, the board will not let a lawyer use demonstratives at final argument unless the exact demonstrative has been previously introduced. Appealing such inflexibility is fruitless because the Federal Circuit affords substantial deference to the board's interpretations of its own regulations, unless those interpretations are plainly erroneous or inconsistent with the regulation. Losing a winnable case because you failed to follow the PTO's rule will not give you a ground to appeal. The Federal Circuit reviews issues of law de novo and issues of fact for substantial evidence. Substantial evidence is that which a reasonable mind might accept as adequate to support a conclusion, and it is a highly deferential standard of review. The possibility of drawing two inconsistent conclusions from the evidence does not prevent an administrative agency's finding from being supported by substantial evidence. So here's the bottom line. An appeal to the Federal Circuit is not going to be effective if you are not able to appeal your best issues. Therefore, it is critically important to understand the IPR process and to raise issues at the appropriate time, in the appropriate way, in the first instance. Otherwise, a party might be left with a great speech and no audience. Thank you.